The following is a paid program on AM 650.
Now, AM 650 presents It's Your Money, an up-close and personal look at your finances. Here's your host, Fred Snyder.
Up in the morning and out to school.
Okay, we are back. Remind you once again, ladies and gentlemen and listeners out there, that this is a live show. So the first hour you listened to was a replay, but today it's for real, it's live. And we share this show with you, our listeners, and we expect your calls. We want your calls. Your calls are part of the show. So get on the line and start phoning, start dialing. Number to call is area code 604-280-0650. If you're calling long distance, it's 877-280-0650. If you want to log on, you can see us live. You see what we look like. www.am650radio.com. And log on there and then click on Watch TV, and you can watch the show from anywhere in the world. Had a call one time from New Zealand as a result of this show. So get on the line, give us a call. And for those who are shy or reluctant to talk on the air, Frida's down at the office right now. You can call Frida at the office. You might want to make an appointment to see myself. Call Frida, area code 604-737-3512. Long distance, 1-800-661-1495. Remind you once again, we want you to call. We share this show with you, our listeners, and we expect you to call. This call might be the first step in a journey that leads you to better financial success. It may be the first step in a journey that helps you achieve financial success or improves your financial situation. It's all about having money, because it's not about how much you make that counts, it's about what you keep. If you spend all your money, you don't have any money, somebody else has your money when you spend it. So you can't have a deficit. We talk about all that and much, much more on this show. I got a caller on the line already. Before I introduce my guest, I'll quickly take that call. It's Bernard from Richmond. Bernard, welcome to the program.
Hello.
Hi, Bernard.
Hey.
How you doing?
Hey, fantastic. Canada Day's coming up here real quick, Fred.
Is that right?
Yeah, and it's on the Tuesday this week, so the holiday changes, and a lot of people spend money on holidays.
Tell me about it.
Yeah, if you know what I mean. So this is
How much do you spend on holidays, Bernard?
Oh, I'll be spending a great day. I'm looking at going to check out the Steveston Parade.
You were telling me the last time that you called in that that retirement was a long holiday.
It is.
Yeah.
It's the endless vacation we all have to plan.
The endless
for.
vacation. That puts it very well.
That's
And
what
yet,
it
if
is.
we don't hang on to our money, if we don't keep some of our hard-earned dollars, we're not going to be able to enjoy that endless vacation.
And, you know, the question is, Fred, is how are you going to spend your Canada Day? Probably with your family.
Oh, I don't know. Maybe.
Fishing?
I don't know about that either.
Choices, right? But
I'll probably spend my time programming my computer because I'm writing a new computer program right now.
Take a holiday.
Well, that's what everybody tells me, but I don't want to because I think working is a holiday.
I know.
I like what I do.
For you, that's what you enjoy. So I guess do whatever you enjoy as a holiday to you.
So, Bernard, what's your question?
Well, the thing is that a concern I have is about the penny that they've taken away from us. The Canadian government. You know how you round it up or round it down.
Yes.
I've come up with a solution to that problem, and what I was thinking is if they hand out 1-cent stamps instead of pennies, it's more affordable because they said, well, it cost 3 cents to make 1 cent because it's copper, right?
Mm-hmm.
So you could have a stamp, and then you know what happens every year?
What?
That you have to do is you got to send that income tax return off. So that's something we could use them for. How perfect.
Good plan.
You know, so we could put the Canada Post people back to work because they're always talking about the super mailbox problem. So that could solve everything.
Yeah.
What do you think?
I think it's a good. Bernard, I think it's a great idea.
Yeah,
Fantastic idea.
Let's go for a promo, and maybe we could get Bill Vanderzam to sign a list. Just like we got one tax taken away, we could maybe bring the penny back. You know.
Bring the penny back.
Remember, we all had piggy banks, and we used to save pennies.
Yeah, you got to feed the bank, or you got to feed the pig.
Now we can't even, so what are people doing with their pennies?
You got to pay yourself first, Bernard, and you can't have a deficit. That's the fundamental secret to financial success, is to don't spend everything you earn. That's where it all starts, and you're not going to be able to manage your money properly if you don't have a proper budget. So everybody needs a budget. Everybody needs to pay themselves first. Part of everything you earn is yours to keep, and that's what you need to do. I have to introduce my guest, Bernard, so I'm going to have to let you go. Really appreciate your call. Enjoy the rest of the weekend. Take care now.
Fantastic Canada Day to everyone out there on the air. God bless. Bye now.
So we're going to skip the case study today because we got a real special program here today. We're going to talk about WESA. And to talk about WESA, we have a fellow by the name of Alfred H. Field. He's a lawyer. He specializes in estate planning and all that kind of stuff. And we're going to talk about estate planning. We're going to talk about wills, and we're going to talk about trusts, and more importantly, we're going to talk about WESA. That changes, generally speaking, in the Wills Variation Act. So, Alfred, welcome to the show.
Thank you, Fred. It's my pleasure to be here. WESA is basically a consolidation of various pieces of legislation which govern the signing of wills, the administration of estates, and succession or inheritance rights. It affected the particular statutes as three in nature. It had some other statutes which it affected, and it consequentially amended 41 other British Columbia statutes. So it's a big omnibus amendment with respect to the estate administration. So we have all of the things that we need to know about wills, estates, and inheritance in one statute. It also, as a consequence of that, amended the Supreme Court rules and the process to obtain a grant so you can administer a estate is now somewhat different. And so we're now struggling with learning the intricacies of the statute itself. One thing that did happen prior to the WESA coming into effect, which was March the 31st.
Repeat that again. What does WESA stand? That's an acronym for what?
Wills, Estate, and Succession Act is what the acronym.
And why is that important to our listeners?
It's important because it affects the wills and how wills are signed, how wills can be interpreted. It affects how an estate is administered and what the obligations of an executor are, how they apply for authority from the court to administer an estate, and it also affects the inheritance rights that people have and what happens in the event there isn't a will.
I was just going to ask you that question. What happens if I die without a will?
Then the inheritance is governed by the succession provisions in the WESA. And in particular, it's a little different than what it used to be with respect to a will.
Are the rules different in various provinces?
Yes, they are.
Is WESA unique to BC, or is it?
WESA is unique to BC. There can be similarities in other provinces for inheritance rights, but each province has its own inheritance laws. There can be comparables, but the rights are governed by our statute for our estates.
In British Columbia, we used to have what they called the Wills Variation Act.
Yes, and
how does WESA affect the Wills Variation Act?
Only marginally. The Wills Variation Act is incorporated into WESA. The rules with respect to bringing an application for to vary a will are very similar. There's two changes that are make it different. One is they have a slightly different period of time in which to make an application to claim against an estate. It's now 180 days. The second item in the wills variation provisions is the claim must be served on the executor within 30 days of the filing of the claim under the wills variation.
Let's take an example for clarity. Let's take an example of that. Let's suppose that I have 3 kids and I decide to disinherit one of my children. How does the Wills Variation Act affect that?
Each of your children has the right to make a claim against your estate to have the will varied. So the child who's been cut out of the estate has a statutory right to make a claim against the estate for a different share than what they received in your will.
How does that tie into probate?
Probate is the will that you drafted cutting out one of your children would, if it required probate to administer the estate, would set the limitation period as to when the person could make a claim against the estate.
Would the claimant generally be successful?
It depends on the circumstances and whether they're properly provided for in the views of the court.
So it's pretty difficult to disinherit somebody.
It's very difficult to disinherit somebody.
Okay. And supposing I decided to transfer my financial assets to segregated investment funds, which are contracts issued by life insurance companies where you can name beneficiaries, and I were successful, I were able to do that with all my assets. And I left 2 of my kids as beneficiaries, excluding the third one. Would that work?
It can work very well to exclude the child in those circumstances because there would be no estate being administered upon your death.
I was able to get rid of my estate, essentially.
That's one of the planning tools that people could use to.
But if I owned a house?
If you own a house in your name, that house would form part of your estate and would be subject to a claim by a disinherited child.
Unless I registered that house jointly with 2 of my kids, and excluding the third one.
That can be of assistance, but there's other factors that come into play, whether in fact that actually transferred the all of the interest to the children appropriately, and whether they can make a claim and challenge the actual joint tenancy that would have been created.
Supposing prior to my death, I were to transfer assets to 2 preferential beneficiaries at the expense of the third one, my third child, I were to transfer assets, would that work?
It can work. If you
They can't come back and claim that.
If it's a valid gift, the gift could be made to exclude any other person, so you could gift an asset to a preferred beneficiary, whether that's a child or a charity, wouldn't matter.
So what are some of the specific changes that have been made in WESA?
Some of the specific changes in WESA relate to, and I can just review some of them with respect to what WESA has done and caused some degree of, I guess, concern among the profession. Basically, pre-WESA wills are valid, and the formal requirements that have been met will result in a valid will, and WESA isn't retroactive. One thing that WESA has done is that the WESA will apply to a person if they die on or after March 31st. So if they've died prior to March 31, WESA doesn't apply to their will. But if they're
March 31st of this year.
Of this year, 2014. And so one of the things that WESA has done is that a will is not automatically revoked upon marriage. So if a person gets married...
In the past it was, but not now.
It's not now. So in March 31st or after somebody's married, their will that was done prior to March 31st of this year is still a valid will. The second, one of the other things that WESA has recognized is that a debt that was used to acquire an asset becomes a responsibility of the beneficiary of that asset. And it distinguishes between debts that are created to acquire an asset. So if you buy a house and have a mortgage that helps you buy that house, and then you kindly give that house to me, I become responsible for the debt mortgage against the house. On the other hand, if you have a house and you take out a line of credit and give me the house, I'm not responsible for the portion of the mortgage relating to your line of credit. So they distinguish between the use of the funds that charges the asset and the responsibility for that debt.
The funds borrowed against the line of credit could have been used for other purposes other than buying the house.
Yes.
Or if there's a mortgage, it was probably used to buy the house.
Yes. Now, oftentimes they blend mortgages today. Their mortgage is taken out and they have a line of credit portion and a portion for the mortgage relating to the house purchase. So record keeping is very important. And of course, the will can address the application of a debt and deal with how or who is responsible for the debt in a very capable fashion. The other thing that WESA has done is the courts have much broader powers to cure deficiencies that may have occurred in the signing of a will or the creation of a will. And so the courts have much more ability to make sure the intention of a will maker is carried out. It uses the term record, which expands upon what we formerly thought of as a will. So record is defined to include data that is recorded or stored electronically, can be read by a person, and is capable of reproduction in a visible form.
This is an extremely important issue that you're bringing up. When I had my first overview of WESA the other day, when I thought, well, to get you on this show would be a great idea, but you got to really be careful what you write down.
That's correct.
That can become part of your will. I want to focus on that just to make sure that people understand. Let's say that I send an email to my brother and I say something in the email. That could be considered part of my will?
Yes, it could be considered the will if that was incorporated as your intention for distribution of your estate.
A little note in a file could be
considered a record and part of your will or your wishes.
Well, this is a huge change, is it not?
Yes, it's an absolutely dramatic change, and there's been lots of speculation among the profession as to what would include a record, and there's been some concerns expressed as to summaries recorded in a smartphone. And whether
it could be on my cell phone.
It could be on your cell phone if it accurately records your wishes, because that, of course, can be recorded in visible form today through the technology that we have. Voice messages sent to somebody or a third party. So leaving a message on or a recorded message to somebody could become a record. Handwritten notes on various pieces of paper could be considered a record. Summaries of meetings with financial planners could become a record and could be important. And we have not yet concluded what we need to do as a profession when we're dealing with records and summaries of what a will maker's intentions are.
I'd just like to overview the financial planning process, because financial planning really is about establishing financial goals, about having a proper cash flow so you have a positive cash flow, about saving money and investing money and growing money and protecting and preserving that money, and at the end of the day, passing those assets on to your beneficiaries. And we're at the final stage. We're talking about how you transfer assets at your death to the intended beneficiaries without confusion and taxes and all those other issues. This is why this subject is extremely important for anybody who's interested in personal financial planning and having a proper financial plan. The tools that exist in estate planning are like trusts, your testamentary trust, the WESA that we're talking about right now, and the Wills Variation Act in British Columbia, the variation in estate law from province to province. These are all very, very important issues. And if you're listening to the show and you have and let's say you're wealthy or you have a high net worth, this is extremely important to you, because I've seen it over and over and over again in my career, in my own family. When people pass away, the estate issues they have are huge, absolutely huge. I've been asked many times to be an executor, okay? I wouldn't touch that on a bet. It's conflict of interest based on the business that I'm in. And the duties of an executor are huge.
Yeah, very
okay?
much so.
You can be sued if you mess up and you don't do a good job. These are all the things that we need to focus on. But if you're listening to the show and you're out there right now and you have questions, this is your opportunity, because you need to make sure that you're not going to be victimized by the Wills Variation Act, that you're not going to be victimized by not having a will, you die intestate, or you have a proper will. And the proper will distributes your assets in a very effective and efficient way. That's the kind of thing that we're talking about. So again, very, very important that you tune into this show and maybe give us a call. So if you got any questions regarding this issue, get on the line. The number to call is area code 604-280-0650. Long distance 1-877-280-0650. Log on www.am650radio.com. Click Watch TV and you can watch this show live, or you can call Frida if you're shy or reluctant to talk on the air. Frida's down at the office right now, area code 604-737-3512. If you're calling long distance, 800-661-1495. Once again, Frida down at the office, area code 604-737-3512. Long distance, 800-661-1495. Give us a call. Let's talk about your money. More importantly, about your money and how to keep it. If you haven't got a financial plan, it's time to get one. We offer a financial plan to all people who call this show, no obligation or cost. We give you an MRI, an X-ray, a CAT scan, if you want to call it that, of your investment portfolio. And we analyze it according to expected rates of return and according to risk and whether that portfolio is suitable. And the key word is suitable for your set of circumstances. So all that and much, much more is what we talk about on this show. So get on the line and give us a call. So back to you, Alfred. This WESA is really it's a big fork in the road.
It has a very dramatic change in how we do things. One other very significant change is the survivorship rules. And under WESA, survivorship means you've survived for 5 days. And the impact of a survivorship on an individual, and we think of the common circumstance where we have a house in joint tenancy, one or the persons are involved in some form of disaster. We always use as the example, car crash, plane crash, those types of things. If you don't survive for 5 days, each person is effectively got 1/2 of an interest in the property, which needs to be disposed of.
Now you got 2 estates.
Now we've got 2 estates, and we have either the will governing the person's affairs, or we have rules of intestacy governing their affairs. Now the rules of intestacy are quite different today. We have changed them, and they've gone to what is referred.
And there's been changes in WESA on that one too, right?
This is WESA's changes on the intestacy rules.
So that means I die without a will.
No will. And then your estate is governed by the rules set out in WESA for inheritance.
So if I die without a will, I really do have one. I have the one that the government writes for me.
That's the will that you have.
Yes.
And one of the things that the government has done in WESA is that if the person is further removed than the 4th relationship, the monies in fact go to the government. And this is new.
Well, they need it, of course.
They need it, of course. So what we would like you to think about is a will would be a better choice rather than having money go to the government. Now, you can make a claim against the government under moral or legal grounds that the money shouldn't stay with them. I have no idea as to what the government would do on an application of that sort. In past, under the escheats provision, the government hasn't been particularly possessive or draconian in my experience, but why run the risk? But in any event, it can be that if somebody dies without a will, that the person who would receive wouldn't go beyond a first cousin. What they have done is they recognize that both sides of a family have similar inheritance rights. So if it's the mother's side of the family and the father's side of the family are recognized under the inheritance rules under WESA. So they are, previously it was the closest relationship regardless of whose side of the family that closest relation was. So they have changed that quite significantly.
So let's say that I die without a will. How are my assets distributed?
Well, the first thing we need to know is, do you have a spouse?
Yes.
If you have a spouse, then and you have only children from your relationship with that spouse, then your spouse gets the first $300,000 and the household furnishings, and then the balance is divided up 1/2 to your spouse and the other half to your children, regardless of the number of children.
Well, let's say that I have a spouse, and let's say I have 2 children from her previous marriage and 3 from mine. How are the assets now distributed?
The children from your spouse's marriage, unless you have adopted them, are not part of the inheritance of your estate. So only your natural children or adopted children would share in the inheritance.
Okay.
The other thing that WESA has done is under the inheritance, the spouse has the right to make a claim against what we think of as the family home. And that can be their share of the estate and can be part of their inheritance receipt from the intestacy. The court also has the power to order the other beneficiaries, which would be your children, to finance the acquisition of the family home if there wasn't enough assets in the estate to permit the purchase of the family home from the estate and carry a mortgage over the term that the court dictates would be appropriate.
What about constructive trusts and things like that? That have any impact?
WESA hasn't specifically dealt with constructive trusts. I'm going from my memory here of anything that sets up a constructive trust recognition. That generally the Trustee Act would. There are estate trusts that are set up that would be trusts. I'm not sure what you're asking.
Well, let's say that one spouse contributes substantially, doesn't own the house, but contributes substantially to the house by paying taxes and all that kind of stuff. So does that not create a constructive trust?
It could create a constructive trust. We see that more in the family law arena rather than the estate arena.
Fine. Gotcha. Okay. So bottom line is, I think we have to go to the break. Just got a signal, so we're going to the break. And when we come back, we'll continue to talk about WESA. So don't go away.
Fred Snyder.
I want people to call the show that are genuinely interested in increasing their financial IQ so that they can become financially independent sooner and stay financially independent longer.
Fred Snyder.
You don't have a blueprint. Imagine trying to build a house without a blueprint. And how about having a blueprint for your life? What are your lifestyle goals? You need to think about your family life. What are your goals about your family life? What are your lifestyle goals when it comes to health? What are your lifestyle goals when it comes to finances, mental and spiritual? You have to set goals in all those areas, not just finances.
Fred Snyder.
Often we fail because we put too much emphasis on one area and ignore everything else. We work our butts off and we ruin our health. So life is all about balance. So you need a life plan.
Fred Snyder.
Napoleon Hill says this, wrote the book Think and Grow Rich. Anything that you can vividly imagine, ardently desire, and enthusiastically act upon will inevitably come to pass.
Fred Snyder.
My goal, my mission is to help people enhance their financial IQs by teaching them what they need to know to make better financial decisions.
Fred Snyder. Sunday mornings at 9 on AM 650. This is CISL Vancouver. All-time favorites. AM 650.
Get rich quick, this is my lucky day. So stick around, baby, and everything will be okay.
This is It's Your Money on AM 650. Here once again is Fred Snyder.
Hey, we're back. Remind you once again, ladies and gentlemen, this is a live show. We're talking about your money, more importantly about your money and how to keep it. And I'm personal financial planner Fred Snyder, if you just joined the program, and I'm talking with Alfred Field, who's a lawyer with Watson Gopal, and we are talking about WESA, which is changes in the Wills Variation Act and really the whole act in BC as it comes to estates and things like that. So we can talk about trusts, we can talk about dying without a will, we can talk about the Wills Variation Act, and much, much more. So you're out there, you got questions, time to make a phone call. Get on the line, give us a call. I remind you, we are inviting you to participate in the show. Maybe you have some comments. Maybe you have some questions. I want to just kind of review the issue when it comes to the financial plan, the plan, okay? That's what investors calls it. They call it the plan, like it's God almost. And it kind of is when it comes to your money. So what kind of a financial plan do you have? And what constitutes a proper financial plan? First of all, it's in writing. Secondly, there's a section in the plan that's devoted to establishing goals. another section that establishes or helps you evaluate where you stand right now. There's a section in there on cash management, which is really about a budget. A section in there that covers risk. We're talking about insurance needs and things like that. A section which covers debt reduction, how you eliminate bad debt and replace it with good debt, or eliminate debt altogether. A plan for retirement. What does your retirement plan look like? A plan for capital creation, which is money outside of your RSP. And if you do all those things and you do them right, you're going to accumulate a very large estate, providing you have enough time to do so. And we're talking right now about how you distribute your estate to your beneficiaries when you pass away. And the last step in the financial planning process is the overall review process. How do you make sure that your plan is up to date? How often should you do that, and what's the process? So a financial plan involves 10 steps, really. Education goals, evaluating where you stand right now, plan for managing your cash, plan for managing risk, controlling your debt, plan for your retirement, capital creation, estate planning, overall review. But our focus today is on number 9, which is estate planning and the changes that have been imposed by WESA in the overall estate planning process, because that's a big change, is it not?
It is a dramatic change.
Okay. So if you think that you have a proper estate plan in place, it's time to take a second look at it right now. So I encourage anybody listening to the show to call Frida, make an appointment, come on in, give Alfred a call. You can reach Alfred. Do you want to give your number out, Alfred?
Sure, if you want.
You go ahead. Here.
If you have a question you want to ask specifically, you can give us a call at 604-688-1301.
Okay, so once again, you're out there. Your financial success depends on your financial plan. I say this many, many, many times. There are 3 P's that you need to focus on. The first P stands for plan. The second P stands for planning. And the third P stands for the best products inside your financial plan. That's what I do. And part of the products that we talk about when we talk about a financial plan is having the proper insurance and having the proper estate plan. So what is the biggest thing that you see in terms of talking to your clients, where they make mistakes?
The biggest problem that I find is people are reluctant to finalize their estate plan. They want to think about it extensively, and there seems to be almost an inertia or reluctance to finalize a plan. And I'm not sure whether the reluctance is they're worried that if they do the will that that's going to promulgate or encourage a death, and that doesn't happen in my experience. But there just seems to be a real inertia to actually finalize the will itself.
Well, I find that on this program, Alfred, I encourage people continuously to get themselves a written financial plan, and not very many people take me up on it. Why wouldn't somebody want a no obligation and absolutely free pro bono written financial plan? Why would not everybody beat a path to your door for that? It blows me away. I don't understand it. They used to charge $3,000 for a written financial plan. It's free. What's the standard cost of a will and an enduring power of attorney these days?
Well, it can vary depending on the circumstances, and that's part of the reluctances to provide the information so you can do the appropriate plan. But the costs vary depending on the circumstances and the person's assets and their obligations and their stage in life. But it can be very expensive, or it can be quite affordable.
What's the difference between a representation agreement and an enduring power of attorney?
The enduring power of attorney is strictly related to finances. The representation agreement relates to health care decisions.
So you would really need both.
You need both. In fact, what we recommend, not always, but in a lot of circumstances, we recommend a will, we recommend a power of attorney, and an enduring power of attorney, and we also recommend a representation agreement.
So for the sake of clarity, define an enduring power of attorney. What is it?
An enduring power of attorney permits another person to make decisions on your behalf relating to your financial matters. And they can do virtually anything you as an individual can do under that power.
Do they need permission from me to do that?
Not if you've provided them with a power of attorney and delivered that to them.
Mm-hmm.
And so if they have the power, they can in fact start making decisions on your behalf unless it's restricted in some way. And sometimes enduring power of attorneys are restricted to only occur and be valid in the event of your incapacity or some future event.
So the power of attorney would normally be in place whether I'm incapacitated or not. But if I was incapacitated, it would still come into play.
It would still come into play.
Hence the word enduring.
Enduring. Beyond your incapacity.
Okay. And the representation agreement.
Representation agreement can occur under an event, which can be a doctor or psychologist or psychiatrist certification that you're not able to make healthcare decisions, or it could come into play when you sign or endorse, like a check, the representation agreement.
So if you were sitting down with a client, let's say a potential client, came into your office and sat down and you were doing a will for the client, I would assume that you would naturally recommend an enduring power of attorney and a representation agreement.
I recommend that they consider having those. They're not always appropriate in all circumstances, but it's something that we encourage them to consider having in place in the event of incapacity occurring, more so as people get older or they're facing some illness or sickness.
When would it not be? Can I have an example when it wouldn't be appropriate?
Well, one of the problems we have had with power of attorneys is people start abusing the rights that are afforded to the attorney. So we are very concerned who receives the power and under what circumstances they are able to use that power of attorney.
Okay, so the bottom line is that everybody needs a financial plan, and what we're talking about is the estate planning part of the plan. It's a plan within a plan.
Yes.
So you've got an overall financial plan, and part of that plan is your estate plan. And your estate, what is an estate? Define that.
Well, there's two estates. The estate is what you presently own. Mm-hmm. That's the simple part. And then the estate from in administering after death could be next to nothing if everything has been provided or already dealt with. As you mentioned earlier, we could have had designations already made in the asset, and so when the person dies, there is no estate belonging to the deceased individual. It's already been dealt with at or as a consequence of their death.
So you do trusts and things like that.
We do trusts. And
what's an alter ego trust?
An alter ego trust is a trust set up for the benefit of somebody who's 65 years of age or more.
So you got to be over 65.
You have to be over 65, and you can place your assets into the trust to be administered on your behalf. The only beneficiary of that trust during the lifetime of that individual is the person who is 65 years of age or older, or their spouse, who should be 65 years.
So it'll be myself or my wife in my case.
In your case, it would be. And they could be a benefit. They can have joint spousal trusts and qualify as an alter ego trust.
Why would I do that? Why would I set up an alter ego trust?
The alter ego trust is oftentimes set up for one of two reasons. One is to avoid claims under the Wills Variation Act, so your estate is already dealt with and it does not form part of your estate. So that
gets around the Wills Variation Act.
Gets around the Wills Variation Act, and also gets around with requirements to probate the assets that have been placed in the alter ego trust.
Okay.
So avoiding probate fees would be another reason why you'd set up an alter ego trust.
So if I have an alter ego trust and I pass away, what happens?
The assets that are in the alter ego trust are administered in accordance with the terms of the trust and dealt with, and oftentimes are dealt with in the same way you would deal with your assets that were in your estate by way of will. So the provisions could be similar as to who would receive the benefit of those.
How are they taxed?
Well, they're not subject to probate fees, but they would be subject to income tax fees, depending on who the beneficiary of the asset would be. So your spouse would receive preferential tax treatment under the Income Tax Act, but other beneficiaries wouldn't, and it would be subject to all of the capital gains taxes and realization taxes that would be imposed.
So there's no real tax benefit.
No real tax benefit from the
income tax. It's probate that we're talking about.
Probate, primarily.
How much are probate fees in British Columbia?
$14 per thousand, so 1.4%.
1.4%. Okay, so you're out there, you're listening to the show. You must have some questions. Get on the line and give us a call. We're talking about your money. More importantly, we're talking about your money and how to keep it. And if you just tuned in, I'm certified financial planner Fred Snyder, also registered financial planner representing Scotia McLeod. And I'm here with Alfred H. Field, who represents Watson Gopal. He's a lawyer. He specializes in estate planning. This is his area of expertise. And we're taking your calls. So the number to call is area code 604-280-0650. If you're calling long distance, it's 877-280-0650. You can log on www.am650radio.com. Click on Watch TV, and you can watch us live from anywhere in the world. And if you're shy or reluctant to talk on the air for any reason, you can call Frida. Maybe you want to make an appointment for a second opinion on your investment portfolio. Maybe you want to access our offer for a written financial plan. Call Frida, area code 604-737-3512. Long distance, 800-661-1495. Remember, once again, talking about your money, more importantly about your money and how to keep it. How to keep it is the most important part, and most of the time we don't do a very good job in that area because they didn't teach us in school how to keep our money. And so if you want to hang on to more of your hard-earned dollars, it's time to make a phone call. Ask yourself this question: how long have I worked? How much money have I made? How much of that do I have left today? And am I happy with the answers? And the odds are that you're not, because you did not achieve your potential financially because you didn't know how to do it. That's what we're talking about. And again, a written financial plan everybody needs. We have questions always about life insurance, about wills and estates, about investments, about risk, about expected rate of return, about asset allocation. How do you set up your investment portfolio so that it's maximized and so that it works properly? What's the efficient frontier? How do you manage risk? Harry Markowitz and the Sharpe ratio and all those things are ways to measure all that. Someone once said to me, if you can't measure it, you can't manage it. I'm going to say that again. If it can't be measured, it can't be managed. So you have to find a way to measure your financial success. How do you measure it? Let's talk to Kathy from Vancouver. Kathy, welcome to the program.
Hi, thank you.
Hi, Kathy, and thanks for calling.
I'm listening once again this morning, and I'm just wondering, is it Alfred that's with you?
Yes.
I'm wondering if Alfred has any experience in the disability side of trusts, like a discretionary trust or a registered disability savings plan, that type of thing.
Some minimal experience. We have had experience in providing for disability trusts or the Henson Trust in wills. We have set up and organized some disability trusts and worked through the requirements so you don't go offside with the government funding. There's more and more things that are coming about that, and we're meetings through our various professional organizations with the government people to make sure things are set up properly. I'm not sure that answered your question, but gives you a little bit of an overview.
Well, my husband and I are in our 60s, and we have a son in his 20s with disabilities. So we are trying to make sure that we are doing all the right things and setting a plan in place for him. We do have a discretionary trust, which means that he doesn't have control of the trust. Someone else does once we go. And we're finding that the income tax paid out of that trust just from income earned every year is more than the income earned. I mean, we have to find a better way to work within that trust. But aside from that, we're just looking at redoing our will and our estate. And he's going to have his registered disability savings plan as a retirement thing there. And then there's going to be whatever is in his trust to help with yearly living expenses. But what I wanted to make sure was if my husband and I were incapacitated, I mean, we could be in an accident and for 20 years be living off our own estate and not be able to continue to contribute to our sons or manage our sons, and how to put something in place for that possibility. Am I making sense here?
You're making sense, but you're talking a funding issue, I'm assuming, as opposed to a planning issue. When I say planning, I'm talking about estate planning.
Yeah.
Or trusts or wills, but your question relates more to the funding of the plan.
The underlying investments.
Yes, exactly.
And that's, you should speak to Fred.
Yeah.
Oh, is that right? So it would be Fred. Because
it's a combination of both, Kathy, because you know, the box that you put the investments in is the trust itself, but the investments themselves are a whole different issue, because my job as a investment advisor is choosing investments. It's the selection of the individual securities that goes into the investment.
Yes.
So I have a process, I have a way that I can search and find the number one top performing investment funds and stocks and other securities that are out there.
Okay.
So the part of the plan that involves that is the capital creation part and the retirement savings plan. So retirement and capital creation are part of the accumulation of wealth, and that depends on the investments themselves. But we're talking about a trust structure, which is another issue.
Yes, and I don't think we're managing the trust well. We did start it about 7-8 years ago once he transitioned into adulthood. But the fact that it's costing so much just to have the trust, we should have it coming out as income to him, because his income, we're doing something wrong.
Well, maybe it's time for a second opinion. Maybe you should call free to make an appointment, come in and see me. Or, again, you know, that could be one approach, or make an appointment to see Alfred and have a chat with him. You really need to talk to the two of us, because it's two different issues.
And it's complicated. And one thing you've made me realize is you've got to get the information and make informed decisions on these things.
That's exactly right.
So, okay.
So, Frida, excuse me, Kathy, give Frida a call.
Okay.
And, you know, we'll take it from there.
Thank you very much.
Appreciate your call. Enjoy the rest of the weekend.
Thank you. Bye-bye.
Bye for now. Let's talk to Malcolm from Langley. Malcolm, welcome to the program.
Good morning, Fred.
Thanks for waiting, Malcolm.
Not too bad. Actually, a question for your guest this morning. It's regarding the wills, and when this new rules and regulations come into force now, how would that go with a legacy when claims are made against the will? You know, would the legacy leap forward, or would it have to take a back seat until all the claims are made forth on the will?
The distribution is postponed until, I'm assuming you're referring to the will's variation claim.
Yeah, that's right, yeah.
Okay, the distribution for a legacy would be postponed until the time period has expired for filing the claim under the Wills Variation Act, subject to some exceptions, but fundamentally from the date of probate of a will, there is 180 days in which the claimant can make a claim against the estate. And so the estate won't be distributed, and in fact the executor is prohibited from distributing the estate for 180 days from the date of probate.
Right. Okay.
And so then if there's a claim made, then the legacy could be subject to the claim that's being made against the estate.
Okay. Well, as I say, you've answered my question. It's just it sounds a bit complicated, like, you know, but I just wanted that verified in my mind, like, you know, regarding legacies and what have you. So, but anyway, thank you very much, and I appreciate your time and patience in answering my question. And now I'll have to think about all that stuff. Okay. Thanks very much, Fred.
Okay, Malcolm, I'd suggest you give Frida a call. Make an appointment. Come on in, and we'll see what we can do for you.
Okay, thank you very much.
Appreciate the call. Enjoy the rest of the weekend.
Okay, bye-bye.
Bye-bye. Okay, if you just joined us, I'm certified financial planner Fred Snyder, also registered financial planner representing Scotia McLeod. And I'm, again, talking with Alfred M. Field, who represents Watson Gopal. We're talking about WESA, which is the changes in the estate planning that takes place in B.C., focus kind of on the Wills Variation Act and all those other issues. Major changes. So if you have a financial plan right now and you think that your will and everything is the way that it should be, it probably isn't. It's time to take another look at all those issues because it's a new world right now. There's major changes have taken place here in BC. We had a meeting at my offices last week. We had a lawyer in talking about all this, and that inspired this show today. I said, I got to get somebody on the show to talk about WESA because big impact on everybody. So you may think that you've worked hard all your life and you've accumulated a lot of wealth and everything is well looked after and you're going to pass that on to your beneficiaries, your children, your grandchildren, etc. That'll be your legacy. You think that's in great shape. It may not be because of these changes which have taken place. So get on the line and give us a call. Again, second opinion on your investment portfolio, written financial plan. All you got to do is make a phone call. And again, You Can't Take It With You is a great book by Sandra Foster. If you want to read up more on estate planning, that might be a good book, but that book itself might even be outdated right now, right? Maybe Sandra Foster's got to write a new one.
Yes.
And anyway, what I know we've talked about it already, but kind of let's review it. What are some of the, very simply stated, what are some of the major changes which have taken place in estate planning in British Columbia?
As far as WESA goes, it's
major changes.
Major changes. We're looking at how wills are going to be interpreted. We're looking at the power of the court to construct a will being much more expansive, as well as correcting the will if it's been made and caused some issues or problems in carrying out a will maker's wishes. We're talking about who pays the debts and who's responsible for a debt for a gift that has been made under a will. We're talking about a record and what that could include, and so documents that we didn't think were wills now could be considered to be a will. And
I think that's a really, really important one.
That one's kind of scary for us.
I mean, I can have some stuff right on my cell phone, which is sitting right there, which could really defy my wishes. I might have sent somebody an email or something that could be considered to be part of my will.
That could be part of your...
Before we continue, let me take a call. I got Ron from Chilliwack on the line. Ron, welcome to the program.
Yes, thank you.
Hi,
actually, I had another question, but when I hear that part two reminding about what you tell about writing down something, does that not have to be witnessed and so on, like a normal will?
Beautiful question.
Good question. In fact, if you want it to be a will, then you're going to have to comply with the requirements under WESA as far as witnessing goes. However, the courts have much more discretion to admit to probate a document that we formally wouldn't think was a will, and that's what has become the term record. So you writing something down might, subject to the court's approval, become the record and consequently what we would consider a will. We don't recommend that you just jot something down, scribble it down, say, oh, it's good enough, the court can admit that into probate, because that's when we talk about expenses, delays, going to court to prove that that really incorporated your intention as to what you wanted to do with your estate. So,
well, yeah, I don't even know how they would approve who wrote it. I mean, somebody could pick up my iPad and say, I leave such and such to so and so. That's a record, and you know.
That's one of the problems that we face is, did you in fact write it? Is that something that you in fact adopted as what you want to have done with your estate?
Okay, well, sounds like...
Time will tell when we have some legal cases to start to sort this stuff out.
Yeah.
Yeah, okay. Well, my first question was going to be, I got married nearly 2 years ago. Neither one of us had children from previous marriages, and there's old wills around, I'm sure, leaving things to nieces and nephews. We haven't bothered with a new will because everything is in joint name. And we assumed, like it used to be, I guess, that, okay, we don't need a new will because marriage preempts any of those wills, old wills. But now what happens?
Not anymore.
Well,
yeah, so we got...
Yeah, your will was revoked when you got married. So if you were married 2 years ago, any wills you had up to that point in time, they were revoked. You don't have any existing wills. We're assuming no other documents. So you have no will with respect to that. But bear in mind, because we have new survivorship rules of 5 days or more, the joint tenancies that you have described may not, in fact, be the requisite disposition of your estate. So you could end up with an estate that consists of, for example, a half interest in your house if you die in a plane crash, car accident, things of that sort. So your disposition may not govern, or your estate and how it's going to be distributed. So you should consider having a will to deal with those assets that may not be dealt with by your present plan.
Okay.
Okay,
but those old wills I don't need to worry about.
You don't need to worry about the old wills based on what you've told me.
But if you pass away right now, he dies intestate.
Yes, you die intestate. Then you're subject to the problems and difficulties people have. Now remember that an administrator has no authority except by way of court order. So if somebody needs to administer your estate, they need the authority of the court to have any status to deal with your estate. So you're faced with applying to court in order to get the status.
Okay, well, that's the other thing. We haven't really figured out who we want as executor, trying to avoid hiring a lawyer, because I would imagine that's quite expensive, but it is a big job, like David said earlier, to put that burden on somebody else. But do you know what it costs roughly, or percentage-wise, or anything for
an executor?
For an executor, well, the executor's fees are subject to court approval, and they have maximums under our legislation as to what an executor can charge. If you're using a corporate trustee, they have fee agreements that they require in order to become or to agree to accept the responsibility of the executorship.
What is around 5%?
5% is the maximum for what we call a private executor, and 5% on income, and there's another fee that they're entitled to charge maximum, and then it's subject to agreement of the beneficiary or by court approval.
So lawyers considered a private?
They would be considered a private. I'm thinking of trust companies when I say companies.
So you see, you could always appoint TD Trust as an executor, as an example. And sometimes that's not a bad idea.
Yeah, because they have long-term obligations, and they know how to get the job done.
Okay, and if you appoint somebody as an executor and you want to change that down the road, you can always change it.
Mm-hmm.
So you should put something in place. If you don't have anything in place, you don't want to die intestate.
Right.
So you put something in place, which doesn't mean that you can't modify it.
Right. Okay.
Appreciate the call.
Good.
You take care, Ron. Enjoy the rest of the weekend. Okay, if you just tuned in, I'm certified financial planner Fred Snyder. I've been talking to Alfred Field. He's a lawyer. We've been talking about WESA and the changes in the estate planning law and rules and regulations as they are in British Columbia. Many, many changes, and I encourage you, if you have a financial plan, and if you don't have one, you should. If you want one, we offer one at no charge or obligation. All you have to do is give Frida a call. But if you don't have an up-to-date financial plan, it's time to get your financial plan updated, and especially when we talk about the estate planning or the legacy section of your overall financial plan. It's time to take another look at that, a fresh look at that, because the changes are immense.
They are. Okay?
And our listeners, if anybody wants to get a hold of you, Alfred, how do they reach you once again?
You can reach me at 604-688-1301.
And again, you can talk to Frida if you want to take this to another level. Frida's down at the office. Area code 604-737-3512, She'll be down there for the better part of the day. If you're calling long distance, it's 800-661-1495. I'm certified financial planner Fred Snyder here every week, same time, same station, talking about your money, more importantly about your money and how to keep it. And we do have to go, so enjoy the rest of the weekend. Take care. Bye now.